Good morning, everyone. I will be talking to you about fundamental human rights enforcement. Now, basically, there is a rule, new rule, which is the Fundamental Human Rights Enforcement Rule 2009, that, like I say, governs everything having to do with fundamental human rights enforcement. Now, basically, fundamental human rights enforcement has to do with the protection of the human rights or fundamental rights of a citizen of Nigeria. And this is covered by chapter 4 section 36, as the case may be, of the Nigerian constitution, and then also the African charter, which is a charter that has been accepted by the Nigerian entity. So basically, what can be the ground for an action under fundamental human rights is where the right of an individual has been contravened, as has been stated by the constitution, or the right of an individual has been contravened as was stated by the African charter. So you cannot just lift up any action from anywhere because you were fighting with somebody to say it's a fundamental human right application. No, it has to be such that contravenes the provisions of chapter 4 and the provisions of the African charter as regards the human right of an individual. Now, basically, how can you institute these actions? You can institute the actions by any of the means, because the rules, I think, under Order 11 provides that any of the means of instituting actions can be used. So let's take, for instance, you now use a motion, probably a motion of notice. So a motion of notice is used. There are certain things that must be attached. So you must attach what is a statement which is carrying facts showing the person raising the application, the things or the facts that transpired, and then the grounds for which you are raising your application, and then the relief sought. So such a statement must be attached to the motion of notice, which is an application. Then after the motion of notice, after the statements, you have an affidavit. Definitely every motion of notice must be supported by an affidavit. So an affidavit must state out the facts on oath under which you are raising your application. And then after that, you must have a written address, which is also giving a breakdown or a storyline of everything. Then after that, just in case the defendant has a reply or an objection or whatever as the case may be, that person is expected to file within 5 days of receiving this application a counter affidavit and a written address within 5 days. But fundamental human rights applications, one thing you must note is that it is ordinarily fast-tracked, like it is dealt with extreme urgency by the court. So the moment an application is raised before the court and filed, the court has just about 7 days to hear such a matter. So if an application is made 7 days after, at least the matter must be heard before the court 7 days after. So it's 5 days after for a reply to be made to an application, but 7 days after an application is filed before the court, the matter must be heard before the court. Now, I think finally, having to do with the jurisdiction of the court, questions arose as to which court has jurisdiction to handle fundamental human rights applications. In Toko versus Gongola, it was held by the court that it should be the Federal High Court having jurisdiction to handle the matter. But beyond that, there is a case I'll quickly state in Grace Jack versus University of Agric in Makurdi. It was held that it is the Federal High Court and the State High Court that should have jurisdiction. Ordinarily, this is said to be the obiter, but beyond that, questions arise as to how it should be adjusted, because you can't say the both of them have concurrent jurisdiction, in as much as it has been accepted by the Supreme Court that both the Federal High Court and the State High Court has concurrent jurisdiction. But that does not undermine the fact that Section 251 of the Constitution provides for matters under the exclusive jurisdiction of the Federal High Court. So irrespective of the fact that fundamental human rights applications can be raised by both the High Court and the Federal High Court, the matters under Section 251 are exclusively given to the Federal High Court. So every other matter apart from those provided under Section 251 can be handled by the State High Court, as the case may be. Then also, it should be noted that the National Industrial Court has jurisdiction exclusively to handle matters of employment and labor issues. So anytime such industrial matters are arising and relating to fundamental human rights enforcement, it has to also be dealt with by the National Industrial Court. So this is the much I'll be talking about human rights applications. See you next time. This is Moments with Abila.